And welcome to What is a Trust Protector and Do You Need One? I am Jim Cunningham, and together we're going to go through this very, very important topic. Disclaimer, I'm a lawyer. My lips are moving. Words are coming out of my mouth. This is absolutely not legal advice. Please don't take it as such. This is information only. Subscribe to our YouTube channel if you're watching this on YouTube. It's great to stay up to date on all the exciting stuff that is happening in the world of trust and estates. I'm Jim Cunningham. I've been an attorney for 25 years, and we have offices in California. I'm also a certified specialist in estate planning, trust, and probate law, a non-practicing real estate broker, and securities and insurance license, but not practicing in either of those. So our firm helps people, helps you, the taxpayer, pay the least taxes possible. We're here to help you craft a plan, give you options, make recommendations to reduce risk and your overall tax bill, leading to more wealth to yourself, your family, and your loved ones. And if you're a professional watching this, a lawyer, an accountant, financial professional, we also help your clients as well. A trust protector is a really big part of this. So there are three questions that are on most people's mind. And in our firm, at Cunningham Legal, we do use trust protectors. And the three big questions that people have that I really kind of ask myself before even counseling somebody on should you consider having a trust protector, what problem does a trust protector solve? And I hate to be kind of frame it in the negative, but we typically in law, we don't do something unless there's a problem, okay? Why should you consider a trust protector? So what problem, why should you consider it? And what is the likely result or outcome without a trust protector? I think we need to kind of compare and contrast that. And what are the alternatives to a trust protector? And I will tell you the quick answer to these three. What problem does a trust protector solve? You're going to die one day, okay? Your revocable living trust is going to become irrevocable. Your irrevocable trust is not modifiable once you die. If that's even a word, modifiable. And you should consider a trust protector because this ties into number three. If you don't name a trust protector, many of those functions are done by a court, and it's the probate court. And a lot of reasons people do estate planning, and there are a lot of reasons that people use a trust is to stay out of court. So what is it? What is a trust protector? Well, fundamentally, a trust protector is a person who has power over the trust, but is not the trustee. Now, you can think of a trust as a bucket, right? And I've got this bucket and it's got a handle, and you're the trustee and you're holding onto this handle of your living trust. Put your house and your stocks and your bonds and your mutual funds inside of your bucket. You're the trustee holding onto this. Well, a trust protector is someone who has power over the trust, but is not the trustee. Now, this is not typically when you are serving as trustee, when you're alive and healthy and well. Typically, a trust protector steps into action, if you will, when the person who set up the trust is either incapacitated or passes away. And so something else to think about is a trustee has power over the trust, but is bound by the terms of the trust. So a trustee is what is called the fiduciary, and that comes from Latin fides, means loyalty. The trustee must be loyal to the trust, must be loyal to the grantor, the person who creates the trust. And I know I'm throwing a lot of words at you, but I want to tee this up so that you understand that a trustee is carrying out the terms of the trust, but sometimes the terms of the trust do not conform with what we call the grantor's intent or your intent. You may say, well, I want the property to go this certain way. And we've got a few examples in here where, sometimes things change, right? So what if things have changed? What if things have changed and you've passed away, right? Well, without a trust protector, the trustee often has no choice but to go to court. And that is not any old court, that is the probate court. And for most of you, that's why you set up a revocable living trust in the first place, is to avoid probate court. A trust protector is designed to replace a court in most instances. And what a trust protector does is they modify certain very important provisions. I mean, sometimes it's a word or two to conform to the grantor's intent. And trust protectors can frankly give new instructions to the trustee once this trust is modified so that the trustee is lawfully permitted and frankly required to do the right thing. So what I mean is sometimes a person will create a trust and then many years pass and the situation has changed, things in air quotes have changed. And the trustee in carrying out the terms of the trust as they are written is not actually what the person who set up the trust wanted to happen. Okay, and I'll give you some examples of that. Well, first of all, how is this even remotely possible? If you set up a trust, a document, a contract, and you name a trustee and you say the trustee is going to do these things in this manner, in this order, how is it even possible that that can be changed? Okay, so this goes back, I'm not going to belabor this point. We do have a couple of slides on it, but you need to understand some foundational principles with trusts. Trusts have their origin in fairness. Now, trusts originated in the 12th century, that's the 1100s, during the Crusades. And so what would happen is people would go fight the Crusades and they would give their property, their lands, their whatever to somebody else, and then come back. And there's a problem because they've given this property to somebody else. So the Court of Chancery is in Old England, is the court that had the ability or the jurisdiction to rule on things that were kind of church related to your soul. So these would be guardianship, estates, and also land ownership. So let me give you an example. Alfred gives title of his English land to Bert in the 1100s to manage and collects the rents. And then Alfred goes to Jerusalem to fight the Crusades. And when Alfred comes back 3 years later, Bert says, hey, Alfred, you gave me that property. I'm not giving it back to you. It's not going to happen. And then Alfred would go to the king, and the king would say, well, talk to the Lord Chancellor. The Lord Chancellor decides in favor of Alfred on fairness and not law, because the property had been given to Bert, right? Alfred gave it to Bert, but Alfred's instruction was hold this property for me until I get back. And then Bert says, well, I have title. I'm not giving it back to you. And then what happens is this court of equity, it's a term equity, like equitable meaning fair. The Court of Equity finds it unconscionable that Bert could be such a jerk and keep Alfred's lands. And so the court awards those lands back to Alfred. And so what has happened over the last 900 years is that a body of law has developed in Anglo-American law. This is very important to understand. This does not exist on the continent of Europe. It does not exist in Mexico. They do have fideicomiso, which is similar to it. But in the United States and in the English-speaking world, we do have this bifurcation or this split between legal title and equitable title. And why I'm spending so much time on this is it's the trust protector who makes sure, it's like the trust protector is replacing this chancery court to make sure that things are fair, that it is what the grantor or Alfred in this case really wanted. And so we're taking that away from the court and we're putting it into an individual. So I hope you can bear with me on that. So let's say things have changed. And let's say there's this trust that's kind of outlived or is not written appropriate for the current circumstances. Wouldn't it be great to have the ability to modify the terms of an irrevocable trust? Now, an irrevocable trust is a trust that cannot be revoked. It cannot be amended. It can be modified. It can be modified, okay? But does it make sense, or wouldn't it be great to have a function where somebody could come in and permit the trustee to do the right thing? Because many times these trusts are written in a way where the trustee is prohibited from doing the right thing, even though it's the right thing to do. And that's why we need this trust protector, because without a trust protector, you're going to resort to the court. Okay, so you've got trustee, trust protector, court. That's really what a trust protector is for, to keep this out of court. So a trust protector is a third party to the trust. This is really important. It's not the grantor. That wouldn't even make any sense to have the grantor be the trust protector for a variety of reasons. It is not the trustee, right? Because a trustee owes a duty of loyalty to the beneficiaries to carry out the terms of the trust as written. So even if you gave this power to the trustee, in exercising the power, they would technically be in breach, okay? Meaning they would be precluded from doing something other than the way the trust is written. Certainly not a beneficiary. That is a whole host of problems. It should be a person who is not related or subordinate to the grantor. Now, this is the person who sets the trust up. That's Internal Revenue Code section 672C. And a trust protector is a person who performs one or two of these functions, sometimes both. Number one, monitor the activities of the trustee. Okay. Now the trust protector is given powers to accomplish this monitoring. The trust protector has independent authority to go to the bank or to go to the financial institution if the beneficiary says, hey, I think the trustee's ripping me off. Normally you'd have to go through a court proceeding. The trust protector has independent authority to access those records. So cool function. You can remove an offending trustee, meaning a trustee who has gone off the rails, right? A trustee who's using the money in a way that is that violates the terms of the trust. Maybe it's embezzlement. Maybe they're giving money to other people, whatever it is. Folks, it happens. So it's something we have to be really, really mindful of. Also replacing an interested trustee, and we'll cover this a little bit, what an interested trustee is. So we have an example here, but there's no duty to monitor. So the way most trusts are written, I mean, the way we write them, there's no duty to monitor. The trust protector has no duty. Now, it's typically when somebody raises their hand and they say, the trustee's gone off the rails. And so Linda asks, will we be permitted to copy the slides? These are going to be posted. This presentation is posted on YouTube on the slide deck. I think we can certainly post a link there for the slide deck. So the second function of a trust protector, it accomplishes tasks for the grantor that the grantor cannot do personally because of tax, legal prohibitions, or death, right? So meaning if you have a revocable living trust, and you have another grandchild that's born, you can amend your trust to provide for that grandchild. But if you're dead, it's not going to happen, right? If you're disabled, it's not going to happen. And then there are other tax reasons to have a trust protector. So the point of having a trust protector is primarily to ensure that the grantor's intent for the trust is carried out, because the trust is irrevocable and the grantor is not around to say what the grantor wants or to take those actions. So some examples: changing the situs of a trust to a more favorable jurisdiction, moving a California-based trust to Nevada. A trust protector has the power to do that. Now, this is not an adversarial process. This is the trustee and the beneficiary reaching out typically to the law firm, and they say, we finally moving from California to Nevada. We need to move this trust from California to Nevada because we're tired of paying California income tax. Okay, that would be a tax reason. Scrivener's errors, very important issue here. If there is a typo, it happens, folks. If there is a typo, and everyone agrees it's a typo, the trust protector can change that so the trustee can carry out the terms of the trust with the correct, removing the typo or fixing the typo. Modifying the trust because of changed circumstances. I'm reminded of a case we had years ago where the clients had a ranch in California. This ranch was supposed to go to one son. Well, while the parents were alive, they sold that ranch in California and they bought another ranch in Texas. Well, the whole family knew that one son should get that one ranch and not split that with the other family members. But unfortunately, the parents didn't come in time to amend their trust. So the trust protector was able to rewrite that provision of the trust so that the son got the Texas ranch. And that was after everyone agreed. So this is not an adversarial situation. So a trust protector's not some arbiter if there's a dispute. More so, it's everyone agrees that the way the trust was written, obviously mom and dad wanted our brother or son to get a ranch, whether it's the California ranch or the new Texas ranch. Everyone was on board with that. That's an example of a trust protector. Otherwise, you'd have to go to court, probably in California and in Texas. You might have two court hearings. To add or eliminate a beneficiary, I put number 24 here to remind me to mention Kobe Bryant. When Kobe Bryant was killed in his helicopter crash, he had another child. He and his wife had another child, but did not update their estate plan. So in that context, if there was a problem that this child has not been named, the trust protector can come in and conform to the grantor's intent, because obviously Kobe and his wife would want to provide for that child. So that's an example of changed circumstances when somebody's not around to make a change. Kerr asks, if you don't have a trust protector when you set up a trust, can you get one later? How does a trust protector charge? We'll cover that, how the trust protector charges. Yes, you can do one after the fact. Many of our clients do what's called a restatement. So if they have an old trust that doesn't have the trust protector functionality, we go ahead and we do what's called a restatement, and we kind of out with the old, in with the new. Just to give you guys a heads up, no attorney worth their salt will amend a foreign trust. Now, what I mean by a foreign trust is a one that lawyer himself or herself has not written. So something to be prepared for. So top 5 reasons to have a trust protector. Number 1 is tax reasons. There are some powers that are retained by the grantor. This is the person setting the trust up. So this would be you with your living trust. Or there's some powers that are granted to a beneficiary that could result in the trust assets being included in an estate. The Translation into English is sometimes if the person who sets up the trust or the person who's getting the inheritance, if they have certain powers, that means that more taxes are paid when somebody dies. Okay, that's what that means. So a trust protector is able to possess those powers without creating a tax issue, without creating a tax problem. So the trust protector can grant and can withdraw certain powers, okay, to beneficiaries and to grantors. And for example, a trustee being granted the power to add a charity as a beneficiary. There's a reason why you might want to do this. There's a tax reason. I won't get into why you would want to do that. But just the mere ability to add a charitable beneficiary sometimes can have positive tax benefits. And the problem, though, is the trustee has the duty, as I mentioned earlier, to distribute the property to the beneficiaries. Well, if the trustee has the power to add a charitable beneficiary, that means that some people are getting less money. And the problem with that, of course, is that's inconsistent with the trustee's duty to the beneficiaries, right? Which is to carry out the terms of the trust as written. And so a workaround is a trust protector who is acting in a non-fiduciary capacity. I won't get into the difference between fiduciary versus non-fiduciary, but there is a difference. A trust protector acting in a non-fiduciary capacity can exercise that power. And the net result, without getting in the weeds, is less income tax for the family. So many trusts today last for generations. So the second reason to have a trust protector is if you have what we call a continuing trust. Okay, so it's very useful to have a trust protector who can change the trust terms to meet new circumstances. So you set up your trust now, and then this thing continues on for many, many years. We don't know what the laws are going to be in the 2050s, the 2060s, the 2070s. Well, those trusts oftentimes can exist for that long. And so it makes sense to have some built-in flexibility to address those future changed circumstances. So it's kind of like, it's kind of like getting in a rocket and going to the moon with a tool bag, right? You don't know what you're going to encounter, but you need the right tools because it's too late to go down to Ace Hardware and get a tool when you're on your way to the moon. Okay, so similar type of analysis. So an example, a long-term trust example. Mom creates a living trust that on mom's death creates a continuing, what we call inheritance protection trust for son. So this is very common. This trust is designed to provide a level of protection for the son from divorce, from predators, from creditors, to essentially, instead of giving this inheritance, here you go, son, it's in a wrapper, it's in a trust wrapper. And that trust wrapper is designed, okay, it's very important, it's designed to provide a level of creditor protection. Whether it does or not is a different story, but that's the design of the trust. The son is the trustee of this trust after mom dies. And it's very important to understand what you can get to, your creditors can get to. That's just kind of a basic concept in the law. The son moves from Florida to California, and Florida has very different laws when it comes to inheritance protection, very different laws when it comes to homestead exemption, okay, for those of you familiar with Florida and Texas law. And so what this trust protector built-in functionality permits is when the son moves to Florida to decant the trust, to change the situs of the trust, as we mentioned, when moving a California trust to Nevada, but to not only change the situs of the trust to Florida, but do what's called decant the trust. And decanting is like, you take a bottle of nice wine and you pour it out of one vessel into a decanter, into another vessel. And that is the essence of it, is you take the assets from one trust and decant those assets into another trust. This is permitted under law. It's a very esoteric area, but a trust protector can be very helpful in that context. Larry asks, what if a trust protector goes off the rails? Well, we're going to talk about who you should choose as trust protector, and hopefully they won't go off the rails. What if a trust protector dies? We'll talk about succession of trust protectors. So we'll get to that. So a special assets in a trust. So a grantor of a trustee, a grantor names a trustee of the trust, but feels the trustee does not have sufficient expertise to handle a special asset. Okay. The grantor can appoint a trust protector to kind of monitor the trustee. And the example is, same example, mom creates a living trust that on mom's death creates a continuing inheritance protection trust for son. Son is the trustee of the trust after mom dies. So now son inherits her mom's interest in XYZ Inc., which is just a company. and mom appoints Tom to monitor son's handling of XYZ Inc. following mom's death, because mom is concerned that son does not have the expertise yet to run that business, right? Or to pay sufficient attention to the business. So that's just an example of where this person's not necessarily a trustee, but they're there to counsel the trustee, and they're a trustee helper, so to speak. Privacy, this is huge, guys. Privacy is huge, because something that people don't, I think, really put enough thought in is probate is a public process. You know, your assets are actually a matter of public record. So what you own when you pass away is filed with the court. Anyone can see what you owned when you pass away. Anyone can see your debts. Anyone can see who your family is, right? This is very public information. So many trust protector powers that would normally otherwise be handled by a probate court, right? And this would be changing the governing law of a trust, removing and replacing trustees. That's a big one. Interpreting the trust instrument. You know, this was written a long time ago. What does this mean today? Those are many powers that can be held by a trust protector and essentially taken away from the court. And so many of our clients, you know, want to keep stuff private, especially when you got a lot of money involved. And that keeps, the idea is a trust protector, it keeps that out of the court and keeps that out of the public eye. And so again, mom creates a living trust that on mom's death creates a continuing inheritance protection trust for son. Son is the trustee of the trust after mom dies. Son is later diagnosed with schizoaffective disorder. And we see a lot of mental illness, quite frankly, with families. It's not rare. It's not common. We do see it frequently. And that's very challenging for the families, and we get that. And a lot of people, you know, use special needs trusts or whatever that is for people who've already had this diagnosis. But in this case, the son was diagnosed after. The trust protector can remove the son, okay, without having to go to court and without that confidential information being revealed. And so that is very important for privacy. So hopefully the son is getting appropriate treatment and realizes that he may need some help and voluntarily steps down. But if the son doesn't voluntarily step down, the trust protector does have the ability to remove the son without going through the publicity of a court proceeding. What protections are there from the trust protector from the family members? Oh gosh, that's a good one. We'll touch a little bit on who should be the trust protector. Another one is limiting the authority of a trustee. So let's say that the grantor wants a corporate trustee, and a corporate trustee is going to be either a bank or a trust company, maybe even a private professional fiduciary, basically not a family or a friend. Now, California does have a private professional fiduciary designation, and that is an individual who, if you handle 3 or more trusts, you do have to register as a private professional fiduciary. You're fingerprinted, background check, kind of a glorified smelling your breath and checking your fingernails. You know, you have to be an honest person, no criminal activity, that sort of thing. That's a private professional fiduciary. There is a state bar or a state of California website you can go to if you just California private professional fiduciary, if you're looking at that. But so those are the 3 options. When I say corporate, private professional fiduciary, trust, bank, which is typically a large institution, and then trust company, which are typically smaller institutions. But the grantor wants a trust protector to monitor discretionary distributions. Now, sometimes trusts are written this way. I'm giving all of the money to the trustee who will have legal title. Remember our 12th century example. The trustee will have legal title to all of these assets. The beneficiary has the equitable title. So you can think of the bene meaning good, okay? Like that's literally the Latin word it comes from, the benes, the goods. And the equitable title is the equity, right? It's almost like house equity or equity in an investment, but it's also equitable in the sense of fairness. So the beneficiary has the equitable interest. And sometimes people say, look, I don't think the trustee has all of the tools and has all of the knowledge to make a determination when the beneficiary should get money. I think we need some help with that. And this is actually really common in special needs trusts because oftentimes institutions don't want to deal with it, whatever it is. Typically the beneficiary and all that host of other stuff that goes with that. And that would be a person with special needs, maybe a disabled person. So mom creates a living trust that on mom's death creates a continuing inheritance protection trust for the son. Trust co is trustee of the trust after mom dies. The trust protector decides the amount of the distribution to the son, not the trust company. So what this means is the trust company is in charge of making sure that, all the assets are managed properly. But when it comes to the son calling the trust company every 5 minutes saying, I'm in Hawaii, I need more money, that goes to somebody else, because the trust company, and that's kind of an extreme example, but we do see that in practice. Can a trustee, while they're still alive, of an irrevocable trust change a trust protector if he does not trust the trust protector to do the right thing? Can the beneficiaries of the irrevocable trust change the trust protector? Typically not. So you need to choose wisely. And we're going to go over some typical trust protector provisions, and then we'll end with choosing a trust protector. So when you name a trust protector, it's not enough to say, I name Joe Dokes trust protector, period, next paragraph. Now we're talking about distribution. You need to define what that means, because trust protector, it's not like there's a pre-printed or pre-approved by California statute. These are all the powers that a trust protector has. You actually have that with a trustee. Okay. So there are statutory provisions, things that a trustee can do. Trustee powers doesn't exist in California law. Not yet. Will it anytime soon? I have no idea. So appointment, removal, and succession. So you should consider having provisions in there. Who will be the trust protector if you choose to name a trust protector? Now, some practitioners don't name a trust protector. In our firm, we typically do name a trust protector. If a person is not named, then there's a process to name a trust protector. So many practitioners will say, anyone in our law firm can appoint a trust protector. And this is done on a consensus basis. And if you're kind of freaked out about like, wow, that puts a lot of power in the law firm, lawyers are extremely cautious people. Okay. So it's our job is to peek around the corner and see all the bad things that can happen. It's just what lawyers do. And wise lawyers, which is probably most lawyers who even understand what a trust protector is, would be very cautious to take any action as trust protector without broad consensus, is the bottom line. So basically you get people in a room, everyone agrees on what should be done, and then the trust protector typically acts. So you need to have a process to name. It might be, I let my accountant name a trust protector. You should have provisions for the removal of a trust protector. What if they become incapacitated? What if they can't be found? What if they choose not to act? Happens quite a bit. And then a replacement and naming potentially of successor trust protectors. So you should have those provisions in there. The powers of a trust protector, you're held to a good faith standard, meaning, you can't do things in bad faith. You can't double cross people. You can't do bad things. The power to remove a trustee, removing a trustee is a really big deal. Okay. And as I mentioned, either the trustee is going off the rails, or where the mom created a continuing inheritance protection trust for the son gets into trouble with some creditors. The trust protector can remove the son, because remember, whatever you can get to, your creditors can get to. The power to amend trust provisions. Typically, you'll see this on administrative and investment powers. That's very common when you have a change in law. You might need additional powers that you didn't even think you needed back in the day, right? When you did this original trust. Tax and other legal changes, that stuff changes basically every 6 months. Correcting ambiguities and Scrivener's errors, we talked about that. Tax optimization powers, granting a general power of appointment. It's kind of a big deal on this one. A general power of appointment, in many instances, it certainly can help and hurt, but in many instances, it can help to wipe out a capital gains tax bill at death. So if you buy something for $1 and you sell it for $3, you're going to pay tax on that $2 gain, right? That $2 that you've made. When you die, if you bought that thing for $1 and sell it for $3, when you die and your kids sell that thing for $3, typically there's no capital gains tax. And so sometimes it is advantageous and that's called estate inclusion in your taxable estate. Sometimes it's advantageous to have that functionality in a trust, and the general power of appointment, GPOA, is a way to get there. And if you didn't understand that, if you really didn't get that, that's okay. Just know that having a trust protector with a continuing trust provides a lot of benefits. Not having it can either mean you're going to court, or you're going to be paying more taxes, or some other bad thing happening. Okay. The right to examine records of the trustee and third parties. This is really important, where the trust protector says, trustee, I think you're stealing. I want to see your records. And the trustee says, no, I'm not going to give them to you. the trust protector can remove the trustee, right? And then release of powers. The trustee can say, we don't need a trustee anymore or trust protector anymore. So the trust protector says, you don't need a trust protector anymore. I'm closing this out. You can do it. Is there a duty to monitor? No. There is one case out there that says once a trust protector starts to take an action, there is a duty to monitor. There is an affirmative duty to act to make sure the trustee doesn't continue to steal. Okay, so there is one case out there on point. What about fees? Generally, there are no fees until the trust protector acts. Must take an action. Typically, fees, although there are some companies out there who are trust protector companies, and I think they probably charge an annual fee. The fees must be reasonable, and there should be a provision in there for reimbursement of expenses. That might be filing fees or fees to get statements or whatever it might be, but a reimbursement for expenses should be in there. Now, who should be the trust protector? And this is, a lot of the questions came up, well, who should it be? Often it's the drafting attorney or a CPA. Now, this could be the client CPA. It could be the, a CPA that you don't know. Maybe it's a friend who's a CPA. This should not be an employee of yours. So if you own a company, don't have it be your CFO, right? Who happens to be a CPA because that person's employed by you. You can't, that's not a 672C person, Internal Revenue Code section 672. A lot of the functionality, certainly when it comes to taxes, it does need to be an independent person. It should also not be a person within 2 degrees of kinship. Now, what does that mean? That means ancestors and descendants. So ancestors would be parents and grandparents. Descendants would be children and grandchildren, and siblings. That does leave nieces and nephews, maybe, but we generally recommend that people name a professional, whether it's an attorney, a CPA. Questions here. Anonymous asks, is the trust protector obligated to get a consent from all the beneficiaries before changing anything? No, but you have a duty of good faith. So a good faith standard imposed. So, if there are 3 beneficiaries and one beneficiary says, hey, disinherit, the third beneficiary, I'm not sure that's really done in good faith. So, and frankly, that does not come up that often. What comes up more often is all your trustees die, or they don't want to serve, or maybe somebody becomes disabled that wasn't disabled, and you need to change the trust. You need to decant that trust to a special needs trust. Otherwise, this person's going to lose their needs-based public assistance benefits. What if a trust protector decides to remove a trustee for cause and the trustee refuses to relinquish power? Does this go to probate court? I've not had that happen. I think ultimately a court holds the power to definitively remove a trustee. Something to be mindful of: when a trustee serves as trustee in California, typically it's a California resident on a California trust. Just go with me on this. They implicitly consent to the jurisdiction of the courts, meaning in order to have a case brought against you, you have to be personally served. That's a summons and complaint typically, right? You have to be put on actual notice. Hey, there's this lawsuit. Somebody has to serve you these papers. They knock on your door and they say flowers, and the door opens and it's a lawsuit, happy birthday. That's not required with a trustee. A court can make an order affecting a trustee because once you assume the mantle of the office of trustee, under California law, you implicitly consent to the jurisdiction of the courts. And that's very important to understand. So I think to answer your question, Larry, is can the trustee ignore a trust protector removing a trustee? I suppose. What's the next step? Is you go to court. Is a trust protector indemnified by the trust? Typically, yes, Kelly. So a trust protector is recommended when? So when should you have a trust protector? When should you think about having a trust protector? Any continuing trust within a revocable living trust. Now, what I mean by that, a continuing trust is somebody died and the property's not completely distributed. Somebody died and the property's not completely distributed. So a continuing trust, stated another way, a trust that is not a continuing trust says, when I die, sell everything, distribute the property, whatever's left, to my 3 kids. I'm not sure you need a trust protector. Can you make an argument if I'm incapacitated for a period of time, I might need a trust protector? Yes. But would I recommend that? Yeah, I probably would. but it's not, it's not something where I'm going to get intellectually bothered if you don't have a trust protector in there. But if you do have a continuing trust, we really do urge our clients, and really it's a client's choice, right? It's not my choice, but we urge our clients to consider having having the office of a trust protector. Okay. And wherever it goes from there, is an open question. Ira Legacy Trust. So we do a lot of, for those of you on, I'm just looking through names here. I see a lot of clients on here. A lot of our clients have Ira Legacy Trust. What's that? Well, you can leave your IRA to your kid, your $1 million IRA, and say, here you go, kid. Or you can put it in a trust wrapper that provides a plan for that inheritance. And this is really important. I think people, some people live hand to mouth. Some people are worried where their next meal is coming from. Some people live paycheck to paycheck. Some people live year to year. I think that's where a lot of people live, is year to year. What I've seen a common thread with wealthier families, they start thinking in years and decades and generations. Okay. Their time horizon is very broad. When you inherit an IRA, that IRA has zero creditor protection. And a lot of people don't realize this. None. Zero creditor protection. There's also no plan for the IRA, meaning, if you inherit this IRA and don't do anything, what happens to the money? Well, there's no plan, right? So the nice thing about an Ira Legacy Trust, that puts a wrapper around what are oftentimes big assets. Generation Skipping Trust, it's a terrible name. It's also a dynasty trust. It's a trust that is designed to either directly skip a person, which doesn't happen a whole lot. More commonly, the parent leaves it to the child. The Generation Skipping Trust to the child. The child uses the money during the child's lifetime. And then when the child dies, it goes to the grandkids, but stays out of the child's estate for death tax purposes. Super important. Really encourage our clients in that context to have a trust protector. Any irrevocable trust, for a variety of reasons, primarily tax reasons, you should consider having a trust protector. And also, if you want to limit the authority in the trust, if you say, look, trustee, I'm going to give you this authority, but you're going to need the trust protector as a helper, that's when we consider using a trust protector. So how commonly is a trust protector being used? I've spoken a lot on this topic with other lawyers, and I've polled them. About half of lawyers who are experts in this field use trust protectors. Half don't. Okay. These are people who regularly practice in this area. So if you talk to two lawyers, it's a probability one's going to say, yeah, trust protector is great. The other one's like, I don't know too much about that. So among non-expert lawyers, I don't think they probably would just give you a blank look if you said trust protector. Most estate attorneys have at least heard of a trust protector. Our default is to use a trust protector unless, as I said, you're not having a continuing trust, or they're non-essential for very small estates. And I put an asterisk on there because your small may not be your neighbor's, small estate. Somebody may say, oh, $1 million, that's a small estate. Another person would say, well, 10,000 is a small estate, right? I think that is really open to interpretation. So subscribe to our YouTube channel. Here's how you get started. If you would like to meet with us, we've got a QR code here, and I'll open it up for questions. Any more questions that you guys have, you can take that QR code with your smartphone. It's like ordering a meal at a restaurant in COVID now. I mean, I don't know about you guys, but I asked for the menu. I'm like, I don't want to use a QR code. So if you'd like, you can go sign up on our website. This link takes you to the page to make an appointment, and we'll open it up for questions. We do have one question here. Anonymous asks, what is a tax reason to have a trust protector for the irrevocable trust? Great question. So many times we will have a living trust. Whoops. We will have an irrevocable trust, and it's a grantor trust. What does that mean? That when you hear the term grantor trust, that's an income tax. That's an income tax concept. Well, I give some money. I put some money in an irrevocable trust. I'm the grantor. I'm the dad, and I'm using this asset is for the benefit of my child. And I make a gift of $1 million. And it's a grantor trust, meaning I don't get the income, but I'm taxed on the income. So I'm paying the tax bill every year when it comes through. And then I'm like, I'm getting tired of paying this tax bill. I want my kid to pay the tax bill, but I don't want to distribute the assets to my son. Okay. One thing I can do is I can grant to him the right to divert income to himself. All right. that gives him grantor trust status. That's done with the trust protector. Okay, I know it's kind of a legal technical thing, but trust protectors also can have toggle switch, what we call a toggle switch on an Ira Legacy Trust, where whether it's a accumulation or conduit trust, very technical terms, but a trust protector can toggle certain switches. So again, this gets into very esoteric tax concepts. If you're a tax lawyer on here, you're gonna be like, yeah, I know what he's talking about. But if you're a normal person, then it might be kind of tough. But that's one example of a trust tax provision, why you would need a trust protector. So I'll open it up. Any further questions? Anonymous asks, if a trust protector was implemented in a Prop 19 trust and the California legislature establishes legislation that will serve to correct or amend via a constitutional amendment the parent-to-child provision, will the trust protector be able to adjust provisions of that trust based on changes desired by the parent? I would say, Anonymous, I'm going to give you a qualified yes, because that is the basic function of a trust protector. What if the law changes? Okay. What if the law changes? And yeah, I mean, that's the reason we put in a trust protector, is if you have a Prop 19 trust and the law really does take a left turn, unanticipated, we've got the tools, okay? We have the tools to address that change in the law. That is very, very important. And somebody raised their hand. You might want to put that in. I'm not quite sure how to use the raise the hand function, but you can go ahead and put that in the Q&A. We'll give it a couple more minutes. We do have some upcoming webinars. I would encourage you to check out our website where we list our upcoming webinars. We've got a couple of good ones coming up, a lot of great content coming out. I'll give you guys a couple more minutes. And okay, Paul asks, what is the status of SB 668 postponing Prop 19? Ooh, good question, Paul. Senate Bill 668 is a Senate bill that was introduced by a state senator from Orange County that sought to alter the definition of change in ownership when it comes to parents and children for the residence and property with an assessed value of $1 million or less per person. It's a big mouthful. That passed the state Senate 34-4, I believe. I'm going off memory. That is urgency legislation. Urgency legislation. What is urgency legislation versus emergency legislation? Urgency legislation says if it passes the Senate by 2/3 and the Assembly by 2/3, it becomes law. We're anticipating that that will be passed by the Assembly. We literally have hundreds of people on a waiting list to do Prop 19 planning, Prop 13 planning. So we're going to be very busy. How is a trust protector paid? Good question. A trust protector is paid by the trustee. So they direct the trustee to pay the trust protector, pay my invoice. When the house is transferred into the irrevocable trust to the child as a lifetime beneficiary before Prop 19 became effective, should the gift tax paid at the time of the transfer now or at the grantor's death, will the house be included in the estate? Well, it depends, Anonymous, on how it was written. If it is a gift, if the gift was done in tax year 2021, the gift tax return is due when your 1040 is due. And that's April 15 of 2022. You would need to, meet with your attorney or your CPA, complete that Form 709. You also have to be mindful of prior taxable gifts. Whenever a gift is over $15,000 in 2021, a Form 709 federal gift tax return is required to be filed. There is no gift tax due if you have if you have a remaining exemption that equals the amount over $15,000. There's no gift tax due. So you file, but there's no tax in most situations. There's no tax due because we have an $11.7 million death tax exemption and an $11.7 million gift tax exemption. Biden is proposing to reduce that down to $1 million. The gift tax exemption, the death tax exemption at $3.5 million. So I hope that answered your question. What if the limited power of attorney? I think this means what is the limited power of attorney is included for the, what if the limited power of attorney is included for the trustee? I'm not sure I understand fully your question. Any other questions? We'll open. Okay, here we go. If the grantor wants to modify an irrevocable trust, can the trust protector do it? Yes, if the grantor, if nobody's dead, here's the rule. If no one's dead, an irrevocable trust can be modified with consent of all parties because it's a contract. So this is where a lot of people go, what? It's irrevocable. You can't change it. Well, if all the parties agree, you can. Okay. So, and that's if no one's dead. And, you know, if you have minor children, it's, or minors in there, not minors like with the hat and the light, minors, M-I-N-O-R-S, not E-R-S. But if you have minors in there, that complicates things because you might have to have a guardian ad litem appointed. But typically, yes, a trust protector can modify an irrevocable trust. Is it advisable to have more than one trust protector at a time to prevent a trust protector going off the rails? You know, I think if you pick a professional, and you could pick 2 trust protectors. I've not seen that in practice, but if you pick a professional, I mean, the probability of them going off the rails is, you know, I mean, I suppose it's there, but it's less than just the general population. For the gift tax question, what if it is a defective irrevocable trust? Okay, so what you're asking, Anonymous, is there is something called an intentionally defective irrevocable grantor trust, or IDGIT for short. All that, what defective means, horrible word. It should be called effective. Horrible, I mean, defective is terrible because no one wants a defective anything. It means that you give away property that's out of your estate, gone. You still pay the income tax on it. So that's what I mentioned. I give that $1 million to my son and it generates an income tax liability of $10,000. I pay that. I choose to pay it. Let me put it that way. I pay that. The trust can pay it. But if I pay that, that's $10,000 less that's in my estate when I die. So it's a method of reducing the overall value of the estate. And it's a backdoor way of transferring more wealth to the next generation. That's an intentionally defective grantor trust. Any other questions? Now's your chance. Going once, going twice. All right, guys, thank you for watching. Thank you for attending. Here's the QR code, and you can go ahead and hit that with your smartphone. And if you'd like to set a time to meet with us. And thank you for attending today and watching us on YouTube. And remember, subscribe to our YouTube channel. Have a great day.